Hey guys, we have a quick update here in the Courtney Clenney case. Really nothing. If you've been following this case in detail, all of the happenings of the laptop case, there's not going to be any new tea. What's really new about this is it's not so common to see a judge issue an order, and we're going to look at two of them, establishing filter protocols that prosecution teams are supposed to follow. So usually it's just something that prosecutors are expected to do. Prosecutors, when they're going through communications, they should be filtering and they should always err on the side of caution to not violate any communications, violate attorney-client privilege, work product, anything that there's an expectation of privacy that could be a strategy discussion in the course of the defense of a client. So if you are not caught up to speed on some of the happenings of the last year and change, last year, Judge Laura Sheeran Cruz found that the prosecution had violated and had viewed privileged communications without an exception. So that was a big problem. It's a major reason why this trial is taking so long to finally happen. If you missed that news, it's no longer happening on December 1st anymore. The goal is now early 2026 for the Courtney Clenney trial. But let's take a quick look at these orders. There are two. One deals with Apple iCloud accounts, and the second deals with Courtney Clenney's second cell phone device. So they're going to repeat some of the details and steps, but we'll just speed through them because they're only 2 pages. Again, the main thing that's surprising about this is just to see a judge have to put this in writing. So now this is going to be Judge Andrea Wolfson. She will be the presiding trial judge, so we're going to see her name moving forward. You guys, the previous judge was Judge Laura Sheeran Cruz. But let's see what she has to spell out and remind the prosecution team about. So this first one is the order establishing protocol for the handling of certain records. This cause having come before the court and being otherwise fully advised in the premises therein, this court makes certain findings and hereby enters this order establishing a protocol to be followed for the handling of Apple iCloud records seized during the investigation of the above captioned matter pursuant to a search warrant executed on November 3rd, 2023, and identified as related to Kim Clenney and Deborah Clenney, the iCloud records. So Kim and Deborah are mom and dad, so Courtney's parents. And let me pull this banner down. You guys know what we're talking about by now. Make sure you hit the like button, say hey in the comments. So this footnote just reminds us that this is a renewal of a previously issued search warrant. So they had to renew this because the time had run out. And there were also motions regarding the expansiveness of this search warrant and what was extracted. Overly broad, arguments like that. So this court has previously found, with Laura Sheeran Cruz presiding, that the iCloud records contained privileged communications relating to the defendant, who has asserted such through counsel Frank Andrew Prieto and Sabrina Vora Puglisi. The court finds that the state has a compelling interest in obtaining evidence from the iCloud records that is not protected by privilege, and that there exists reasonable means to protect the security of any privileged communications. So this is spelling out there was a violation of privilege. So we need to make sure we hold the state accountable to applying proper filter protocols. We need to babysit you. But also when the defense, and it wasn't just Courtney Clenney's attorneys, there were also efforts by the attorneys for the parents to just completely seal these materials entirely as a whole. And here the courts have found, well, we're not going to seal everything from it. It's still probative. There's still material here that is not protected by privilege that the state has a right to get access to, but they've got to do it the right way. So that's what that means. The court therefore orders the state, law enforcement, and the defendant and her counsel adhere to the following protocol. 1, the state shall assign a prosecutor that is unconnected to any investigation of Courtney Clenney. They're going to be called the Taint prosecutor. The Taint prosecutor will coordinate with defendant's counsel, and together they shall conduct a review of the iCloud records. 2, the court ratifies the state's assignment of Assistant State Attorney Stuart Hedrick as the Taint prosecutor. What a title. 3, the Taint prosecutor shall not keep copies of the iCloud records after the protocol has been completed. The Taint prosecutor shall not store or otherwise make the iCloud records accessible in any system accessible to any other prosecutors or investigators, including but not limited to the VK system and evidence.com system. Now, this was an issue because during the probing, the investigation into, was it just the former lead attorney from the state attorney's office, Khalil Quinnen, was it only him that looked at these things? And they found out that other officers, at least two other officers, said, hey, we were aware of some of these things and we don't know who else had access to them. So that's why we've got to make sure this shouldn't just be like an open an open environment for anybody to poke through. 4, the taint prosecutor shall not disclose the contents of the iCloud records reviewed as part of this protocol, nor discuss them with any person except the defendant's counsel and the court. The taint prosecutor shall not participate in any other manner in any criminal prosecution of Courtney Clenney. The taint prosecutor may petition the court to allow the assignment of additional persons to the taint team. But you can't do it on your own. You have to get permission from the court first. 5, defendant's counsel shall provide a list of filter teams to the taint prosecutor to assist in identifying I read that wrong. They said a list of filter terms. So things, hey, if something contains maybe our names or the word counsel or the word confidential or any other words that might be more nuanced that they can think of, what can you think of that would assist the taint team in knowing what to filter out and not view? So the defense has the opportunity to do that. They shall do it, identifying any potentially privileged communications. Defendant's counsel shall provide a list of account identifiers for all accounts known to have sent or received potentially privileged communications, except for accounts belonging solely to the defendant. The identifiers shall include phone numbers, email addresses, and account handles for all services utilized for potentially privileged communications. So if you're using like Discord, all of that's got to go in there. Defendant's counsel may provide a list of account identifiers for accounts belonging solely to the defendant. 6, the taint prosecutor shall conduct a diligent search of the iCloud records to identify items matching the terms and identifiers provided by defendant's counsel. 7, defendant's counsel may be present when that search is conducted. Defendant's counsel may, during that process, inspect the iCloud records and identify other items not flagged by the taint prosecutor as potentially privileged communications. 8, the taint prosecutor and defendant's counsel shall confer on the items identified in paragraph 6 and 7. To the extent that both parties agree that an item is privileged communication, that material shall be redacted from the records to be provided to the trial prosecutors. That's going to be called the sanitized records. For any items, number 9, for any items where there is not agreement between the taint prosecutor and defendant's counsel as to whether a privilege applies, the court will conduct a review in camera. So in camera is kind of confusing, but that means they'll get together. It's not going to be like somebody standing there recording them and we all get to watch it. It just means within the view of the court. Typically, you don't get to see those in-camera proceedings. You just hear about them, rulings that come about because of them, and make a determination. Any of these items that the court finds to be privileged shall also be redacted from the sanitized records. 10, once paragraphs 8 and 9 are complete, the taint prosecutor shall release the sanitized records to the prosecutors handling the prosecution of Courtney Clenney and to defendant's counsel. So there, it's signed in ink there on the 18th day of November, so that was 2 days ago, by Judge Andrea Wolfson. So there's that one. This second one, again, it's going to be the same thing, but it's just dealing with a different device. So this is going to deal with Courtney Clenney's second phone. This isn't anything new. They seized this device at the time of arrest. So this isn't something that they found this year. They've had this for a while, but it's spelling out because it's a different type of device and it's dealing with a different individual. This is now it's Courtney Clenney's device rather than the iClouds for mom and dad, who also have a client privilege relationship because at some point they did retain Frank and Sabrina as counsel, right? But that's why we have to distinguish these orders. But it's going to take us through the same thing. So they've got to have a taint prosecutor. 2, the court ratifies the state's assignment of Assistant State Attorney Stuart Hedrick as the taint prosecutor. The taint prosecutor shouldn't keep copies of this. They shouldn't disclose the contents to anybody except with defendant's counsel and the court. They can't participate in any other criminal prosecution of Courtney Clenney. Same thing. Defendant's counsel shall provide a list of filter terms. Taint prosecutor shall conduct a diligent search of the contents of the defendant's second phone to identify items matching the terms and identifiers provided by defendant's counsel. Defendant's counsel can be present during that search. The Taint prosecutor and defendant's counsel shall confer on the items identified, and then to the extent that both parties agree that an item is a privileged communication, that material shall be redacted from the records. That's going to be the sanitized records. And then again, if there's no agreement, take it in front of the court for an in-camera review. And then once all that's done, we can release those sanitized records for Courtney Clenney's second phone to the prosecution team. So there we go, you guys. That about wraps that up. If you want these quick docket updates, I usually post them over to Twitter, but I'm going to start doing shorter videos like this as well. So if you aren't already subscribed, if you have not seen me covering the Courtney Clenney case, I've covered as much as I've seen on the docket. We've looked at some of the phone extractions, her journal notes from Courtney Clenney's phone. We've watched a lot of hearings, anything that was publicly available. So if you're interested in this case, we'd love to have you along to continue watching with us and know your thoughts. And as updates come in, we'll keep you updated. You guys all have a good one. Thanks, guys.